Hi, good evening, everyone. Welcome to the live virtual classes of Board of Studies ICAI on CA Intermediate course. As you are aware, we are beginning with a new topic, which we had already started in our previous session. But again, I will repeat certain parts and then we will move ahead with this session. This is on interpretation of statutes. This comes under corporate and other laws. As I've already told you before, there are 4 sessions in other laws which needs to be read by you people. 2 sessions on General Clauses Act has already been covered, and we are beginning with interpretation of statutes. There is no statute as such which is recommended for this, but these are principles for interpretation. And I gave you the rationale why we need interpretation of statutes in our previous session. We'll quickly run through the initial slides, and then I will take you through the specific rules, specific provisions which are mentioned here, or interpretations which have been given by the courts, so that you are in a situation to understand and interpret the principles. Moving ahead, if we talk about the learning outcomes, you can see the learning outcomes is bifurcated into 2 major areas, as you can see here. The first top areas are talking about rules, and the second one is talking about aids. So today we are going to cover all the rules, and in our next session, that is on 27th, we are going to cover internal aids and external aids. Moving ahead, when we talk about interpretation of statutes, deeds, and documents, there is a meaning of a statute, and I refer to Article 13 of the Constitution of India. And I specifically mentioned that when you talk about a statute, it is referring to a legislation. And this legislation does not only mean legislation passed by the Parliament of India, but also the state legislatures, as well as this includes different documents like ordinances. It includes the notifications by the government. All these require certain amount of interpretation at one point in time or the other. There is also interpretation required of documents, and we discussed that in Section 3 of the Evidence Act. Document is defined. So is under General Clauses Act, documents are defined, and documents have a very expansive meaning. So it does not only mean that it should be in a piece of paper, it can be on anything. And that is what is referred to as documents. It can be even inscribed on a pottery or maybe an iron plate. That is also a document. Then we discussed about deeds, and deeds are basically instruments in writing, and which are basically meant for conveying certain things or transferring certain things. This is the idea and objective of the term deeds. We also discussed about classification of statutes. There are different types of statutes, as I told you in my previous session, that though this is not part of your syllabus, but it is important for you to understand the nature of the statute, because nature of this statute will define the interpretation which you will apply to the provisions. Like, for example, if I give you an example of penal statutes, they are very strict interpretation, where taxing statutes are strict interpretation. Whereas when we talk about remedial statutes or welfare statutes, these have a bit of a liberal interpretation towards the subject for which the law has been brought. So these are the different types of statutes: codifying statutes, consolidating statutes, declaratory statutes, remedial statutes, and then we have enabling statutes, disabling statutes, penal statutes, taxing statutes, explanatory statutes, amending statutes, and repealing statutes. All these different statutes, we had a discussion in our previous session, and we had dealt with some examples also in each one of them. And I hope you got those examples. If you have any questions, I will be happy to take that. Let us move further and talk about the classification of interpretation. So this classification, as I told you before, is the classification which is mentioned in your course material. If you read different books of interpretation, you will find the classification may vary, right? So different jurists have classified the interpretation into different ways. However, for your course material perspective, it is classified into legal and doctrinal, which can also be referred to as literal and functional. So in legal, we are talking about authentic and usual, whereas in doctrinal, we are talking about grammatical and logical. So when I say that it is legal interpretation. We are basically referring to rule of interpretation coming directly from the legislature. Okay, and when we are talking about usual, then we are deriving those particular interpretation from some other sources like customs or case laws in common law countries, particularly the case laws. When we talk about doctrinal, this is basically the court's application on the ordinary rules of a speech. And when the court goes ahead and tries to interpret the provision in one way or the other, then that becomes the logical interpretation. So this is the differentiation between the general classification of interpretation. Now, we also saw the distinction between the term interpretation and construction. Interpretation and construction are two distinct terms. However, for the purpose of your module, they are considered as same. And as we saw the distinction which has been brought up by Salmon, who defined interpretation, and he said interpretation is the process by which the court seeks to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. If you see, Cooley gave the definition of interpretation, and he said how it is different than construction. And he said construction is that the former is the art of finding out the true sense of any form of words, whereas the sense which the author intends to convey and for enabling others to derive from them the same idea. Whereas the construction, when we are talking about drawing conclusions, drawing the outcome or respective subjects, what they mean. So you're deriving the meaning out of that expressions or text of the legislature will be referred to as construction. But in a common language, as I told you before, we mean these two terms are similar in nature. So they are basically the same terminology. So you will find many places construction used as interpretation and interpretation used as construction. Now, we were talking about the basic principles, and we had covered intention of the legislature in our previous class. We will repeat that briefly, and then we will talk about the three other basic principles of interpretation. So about interpretation, the whole interpretation exercise rests on these four principles. One is intention of the legislature. This is the primary principle, that whatever you are doing to interpret, you have to go back to the intention of the legislature. You cannot bring something new to it, which legislature has not meant. Similarly, there are when we are talking about the other three principles, it says a statute must be read as a whole in its context, and generally you will talk about plain meaning. So you will not go into the meaning which is inherent or deep, or you would try to conceptualize in your mind some meaning which is not meant there in the plain text. That is not expected, and the plain meaning is the basic principles. And many a times it may happen that the plain meaning of the words are not clear, or there is a problem in interpretation of those words. Then in that situation, you have to make the statute to be effective and workable, so that the statute on the books are not just lying without any interpretation. So when you look at different rules, we will now talk about literal rule, hidden case, mischief rule, all those particular rules. You will find that in all these interpretation rules, the basic principles will be available. So the courts will always begin with starting with intention of legislature. They will be reading the statute as a whole, and they will try to give plain meaning, the effect, irrespective of the consequences. And ultimately, they would try the statute to to be effective and workable. So this is how the interpretation exercise moves on. So for any court or any lawyer, or for that matter, you as chartered accountants also have to be mindful of this fact that you cannot go beyond the intention of the legislature in interpreting the provision. Similarly, when you are interpreting a deed or a document, you cannot go beyond the intention of the parties. So you cannot insert something in the contract by your own will. So it has to be clearly mentioned. Similarly, like for example, if you remember the memorandum of association, articles of association, your company's function cannot go beyond the intention of the memorandum of association, right? So that becomes ultra vires. So these are the same principles which apply when we are talking about interpretation. So now, basically, if I say interpretation is nothing but common sense, so it all boils down to common sense and understanding of the terms in that particular way, right? So this is what is basic principles. Now let us move further and talk about these basic principles. The first principle is intention of the legislature. But before this, in our previous class, we talked about the twilight zone, and I explained you that why interpretation is needed, because everything is not black and white in law, right? So there is a twilight zone, and that requires an interpretation. And I gave you an example of CRPC provision, section 46(4), wherein women cannot be arrested after sunset and before sunrise unless there are exceptional circumstances. Here, the term exceptional circumstances requires an interpretation. And which are those exceptional circumstances? For that, there is requirement of a guidance, which was given in one of the case by Supreme Court in Sheila Barse versus State of Maharashtra, and subsequent cases also. I also told you about DK Basu's case, wherein the norms for arrest has been laid down. So these are the areas where, if there is interpretation is not clear, to find out the intention of the legislature, you interpret this twilight zone to find the meaning actually. So this is what happens in interpretation, and that is the necessity for interpretation. Now, the first principle, that is basic principle, intention of the legislature, when we talk about the duty of judicature is to act upon the true intention of the legislature. And this is referred to as mens. Mens basically means intention, or sententia legis. So this has been held in a number of cases. Either you talk about G. Narayan Swami's case, or Institute of Chartered Accountant of India case versus PricewaterhouseCoopers, or you talk about South Asia Industries Private Limited. All these particular cases have underscored this basic principle, that is, duty of judicature is to act upon the true intention of the legislature. Now, what is intention of the legislature? Intention of the legislature, when you are talking about, you are trying to understand what actually the legislature intended coming up with. And there are different sources, different tools to find out this intention. And that we will read through internal aids and external aids to find, to understand where from you can interpret the intention of the legislature, because intention of the legislature is the words which is expressed in the legislature. It cannot come other way around, right? So this is something which is very important. So it is founded on the premise that every law enacted by the legislature has a purpose, and interpreting that statute in alignment with that purpose is essential for justice and effective governance. So intention of the legislature refers to the objective or purpose the legislative body sought to achieve when enacting a particular statute. It is the guiding principle for interpreting statutes to ensure their application aligns with the legislative will. So legislative will is supreme, right? So nobody can go beyond the legislative will. And this is expressed by way of the written words in countries where statutes are there. Like we are a civil law country where though we follow common law also, but there is a difference between common law and civil law. Civil law basically refers to statute law, where in statutes, and common law is countries which actually rely upon the decisions of the courts mostly. So we had a history of common law, and now we are moving towards more of a statutory interpretation rather than relying on the court's decision. Denning LJ, that is the Justice Denning, talked about this, and this quote, I had discussed this before, but one thing very clearly Lord Denning said is that wherever there is a requirement of interpretation by the judges, they cannot just keep their hands folded, and they say that, okay, now it is not workable, we cannot do anything. They have to find out a way of interpreting the provisions and giving justice to people. And this is where he said that role of judges comes into picture. But at the same time, he says that you cannot supplant, or you cannot, substitute the legislature by providing your views or thoughts, which is not mentioned in the legislation. And that is where the different rules like literal interpretation, harmonious construction, reasonable construction comes into play, which we are going to see in today's class. Now, when we talk about this, let me take you to the further sections. Just a second. Okay. Okay. So we talked about this, and then I also told you about the relationship between these legislature and judiciary, and in many a times to interpret those particular words, you come up purposive construction. You try to understand what is the purpose of the legislation. Okay, so you look at the literal rule first, but if it doesn't work, then you move on to the other rules. I discussed about Cray's on legislation, what he says, and this we have already discussed in our previous class. So I'll move on to the next basic principle, that it says statute must be read as a whole in its context. So you have every statute, every legislation has a context. There is no legislation without a context. There must be something which necessitated that legislation. Either it can be a forward-looking legislation which looks at the future and then it makes the laws, or it can be a legislation to cure a problem, or it can be a legislation for welfare. It must be having some issue which it is trying to address, and hence you have to read the statute in that context. Okay, and then you have to understand what exactly it means. I'll give you just one example of the recent Companies Act, and in the company law, you people are having the provision of having the National Financial Reporting Authority, NFRA, which has been created. Now you have to see and go back. If you have to read the statute on NFRA or a regulation on that, you have to see why that particular body came up, what is the objective of that body, what ultimately it wants to do, and what is its mandate. All these things needs to be understood or clearly underscored around it, right? And recently there have been questions around that, which is probably pending in the courts, and you may be following that. But this is where the interpretation will come into picture. And whenever there will be an interpretation, they will be looking at the context as a whole. So when the question arises as to the meaning of certain provisions in a statute, it is not only the legitimate but proper to read that provision in its context. When you talk about context, context means the statute as a whole, the previous state of law, what has happened before, other statutes in pari materia. So when I say pari materia, means similar to, in similarly circumstances statute. Like for example, if you talk about ICAI Act and ICSI Act, these two legislations may be considered as pari materia because these are two professional bodies. And similarly, ICWAI, these all professional bodies got created by the Act of Parliament. And if you see, mostly these provisions are quite similar apart from the objective of these legislations. So they are considered as a statute in pari materia. The general scope of the statute you want to see, and the mischief that it was intended to remedy. This is something which you want to understand from the statute. So in the case of Union of India versus Elphinstone Spinning and Weaving Limited to 2001, this particular point was laid down by the Supreme Court, or they expressed this in the statute. Now, Lord Davey also said a statement, and he was talking about this principle, and he had to say something in one of the case. And if you read what Lord Davey said, he said every clause of a statute should be construed with reference to the context and other clauses of the act so as far as possible to make a consistent enactment of the whole statute or series of statutes relating to the subject matter. It is spoken of construction, that is ex viceribus actus. To ascertain the meaning of a clause in a statute, the court must look at the whole statute, at what precedes and at what succeeds, and not merely the clause itself. So you cannot just pick up one clause and then interpret that particular statute. So you have to see that clause in the context of the whole statute. So this is what Lord Davey said, and this got further endorsed by our Supreme Court, and they said it is an elementary rule of construction that no provision of a statute should be construed in isolation, but it should be construed with reference to the context and in the light of the provisions of the statute, so as far as possible to make a consistent enactment of the whole statute. So this was laid down by the court in Tulsamma versus Shesha Reddy's case, and the court clearly highlighted this part. When I say here this court, it is basically Supreme Court I am referring to. Then if you see Sinha's Chief Justice of India, Sinha, he basically said in State of West Bengal versus Union of India, and he endorsed these provisions and said the court must ascertain the intention of the legislature by directing its attention not merely to the clauses to be construed, but to the entire statute. It must compare the clause with the other parts of the law and setting in which the clause to be interpreted occurs. It is also apt to take note of few decisions of the apex court with regard to interpretation of the statutes. Now see, he has added an additional element to it. So it is not only the statute which you are referring, but also the case laws on that particular statute has to be referred. This is what Justice Sinha had to say in this particular matter. So ultimately, if it is if you have a look at it, you will try to understand this way. So Tambeshwari, this is not out of course. This is basically part of the course, and this you will utilize it when you are looking at the different principles, because these are the basic principles which goes into all your principles. Okay, so I will draw that relationship, and you will be able to understand that clearly. Okay. Now, let us look at this and try to understand it. You, as students of interpretation at present, you have to be broad-minded and try to read more, because it cannot be a situation, because this is not mathematics, as I told you before. There is always a twilight zone. So you have to read more so that you understand it क्लियरली. ओके, तो अदरवाइज आपको समझ में नहीं आएगा. इंटरप्रिटेशन अब थोड़ा सा टफ है, तो आप अगर सिर्फ वो पॉइंट पढ़ेंगे तो आपको क्लैरिटी नहीं आएगी. जब आप सारी चीजें पढ़ते हैं साथ में, तो आपको क्लैरिटी ज्यादा अच्छे से आएगी. Now let us move further and talk about the role of judges in this context. So role of judges is very important. So while examining a particular statute for finding out legislative intent, it is the attitude of judges in arriving at that particular interpretation and striking a balance between the letter and spirit of the statute without acknowledging that they have in a way supplement the statute would be the proper criteria. Okay, so the duty of judges is to expound and not to legislate is the fundamental rule. So they are not supposed to legislate. They are supposed to give the meaning of that particular word, construction of that particular interpretation, right? So there is no doubt a marginal area in which the courts mold or creatively interpret legislation, and they are thus finishers, refiners, and polishers of legislation. This is what is the term used. So in interpretation, what they do, they will finish, they will refine, they will polish the legislation which comes to them in stating the requiring varying degrees for further processing. Okay, this was held in State of Haryana versus Sampurna Singh. But by no stretch of imagination, a judge is entitled to add something more than what there is in the statute by way of a supposed intention of the legislature. It is therefore a cardinal principle of construction of a statute that the true or legal meaning of an enactment is derived by considering the meaning of the words used in the enactment in the light of the purpose or object which comprehends the mischief and its remedy to which the enactment is directed. Applying the aforesaid principle, we really fail to understand as to how the learned judges of Bombay High Court could come to a conclusion that the mismanagement must necessarily mean an element of fraud or dishonesty. This is with reference to a case Supreme Court had said. In one of the cases, Bombay High Court interpreted that mismanagement would include fraud and dishonesty, and the Supreme Court was lamenting on Bombay High Court in this particular case, and it said courts are not entitled to usurp legislative function under the disguise of interpretation, and they must avoid the danger of determining the meaning of a provision based on their own preconceived notions and ideological structure or scheme into which the provision to be interpreted is somehow fitted. right? So caution is all more necessary in dealing with legislation enacted to give effect to policies that are subject to public and parliamentary controversy. So this was kind of an election petition in which the court, dealt with this particular matter, and they gave this particular interpretation, and they said that controversy for in controversial matters there is room for differences of opinion as to what is expedient, what is just, and what is morally justifiable. It is the parliament's opinion in these matters that is paramount and not the legislature. I gave you one example before, like one nation, one election is the issue which Parliament is trying to discuss, and this a judge cannot give a decision on that particular issue unless it is brought before them in contrast with the constitutional provisions. Similarly, Uniform Civil Code is an issue. Like this, there are many issues which government or Parliament, you can say, has to legislate the law, and it is the duty of the Parliament, and it is the domain of the Parliament. Judiciary cannot give its own interpretation of these particular terms. It is left to the Parliament to decide what law has to be brought up. Now, let us move ahead with the third basic principle, and it says that statute to be construed to make it effective and workable. This is very important principle, and I will give it to you by one example. So in one of the cases, the question which arose was that whether under section 28(1) read with 18A(9) of the Act, it is competent to the income tax authorities to impose a penalty on a person who has failed to comply with section 18A(3) of the Act, right? So here, basically, the object of that legislation was to bring the failure to send estimates. So see, generally what happens is this law brought the idea of sending the estimates, tax estimates, to the tax authorities for advanced tax purposes. And in this situation, that particular advanced tax estimate was not given, and then a penalty was issued on not giving that particular estimate. Okay, and the court was interpreting this provision that whether not giving the estimate can be counted as a penalty or a violation. So here the court, looked into this particular matter, and it said to be that the very object of bringing the failure to send estimates under this within the operation of section 28, that is penalty provision, it signaled failed to achieve its object. A construction which leads to such a result must, if that is possible, be avoided on the principles expressed in maxim "ut res magis velit quem perit." This is the maxim which is there which means basically it is better for a thing to have effect than to be made void. So you have to make the statute workable. In a case of Curtis versus Stoven, the court said the only alternative construction offered to us would lead to this result, that the plain intention of the legislature has entirely failed by reason of slight inexactitude in the language of the section. If we were to adopt this construction, we would be construing the act in order to defeat its object rather than with a view to carry its object into effect. So all these cases, if you have a look at it, our objective and idea is to basically make the statute workable. So the court in this case accordingly was of the opinion that it was competent to income tax authority to impose penalty under section 28 read with so and so section where there has been a failure to comply with the 18A(3), which basically meant for sending an estimates. So this is the case of Commissioner of Income Tax versus S. Teja Singh. You can have a look at this case if you want to. Then the last, another important principle is if the meaning is plain, effect must be given to it irrespective of its consequences. So the law, generally the courts cannot say that okay, if we give effect to this particular provision, then the consequences are very harsh. There is a problem. That they cannot say. Irrespective of harshness of the provision, generally, if the meaning is clear, there is no ambiguity, the meaning effect to that particular provision has to be given. Like say, for example, we are talking about demonetization, right? So during the demonetization period, you can say it may have caused certain problems to certain people, but the law was passed, and that is what the case on demonetization, Supreme Court by majority upheld that demonetization was perfectly legal. There were even if the consequences of that particular interpretation was a bit harsh on the public. So it is well settled principle of law that as a statute is an edict of legislature, the conventional way of interpreting or construing the statute is to see the intent of the legislature. The intention of the legislature assimilates two aspects. One aspect carries the concept of meaning, that what the word means, and another aspect conveys the concept of purpose or object, or the reason or approach pervading through the statute. So if you see here, give me a second, I think there is some presentation is stuck. Okay, yeah. So however, necessity of interpretation would arise only where a language of the statutory provision is ambiguous, not clear, or where two views are possible, or where the provision gives a different meaning, defeating the object of the nature. So here one has to understand that what the meaning is. If the meaning is clear, there is no need for you to give any further interpretation. Let us have an example. The Sussex peerage case. This was an interesting case. Here, the court said that the rule of the construction of acts of parliament is that they should be construed according to the intent of the parliament which passed the act. If the word of the statute are of themselves precise and unambiguous, then no more can be necessary than to expound those words in their natural and ordinary sense. The words themselves do, in such cases, best declare the intention of the legislature. There is no need for interpretation to find out the intention of the legislature. The word itself clearly says what is the intention of the legislature. Let us have a look at one of the cases and recent cases. You people are aware about this case. This is Rahul Gandhi's case in Gujarat. It was filed for defamation. Okay, so he used certain terminology during an election campaign, and the one of the member of Legislative Assembly filed a case in Gujarat about defamation, and there was a judgment given in this particular case by the court, and they imposed a punishment of 2 years. And as per the Representation of People Act, there was a disqualification. So any MP who is punished for more than 2 years, there is a disqualification which comes up. And pursuant to that, there was a disqualification which was given. Now, many people may say that it is very harsh punishment. And it was said, actually, if you see the newspaper coverage during that period, you will see that there was a lot of, questions on this particular matter. But law is law. The law clearly says, even if the outcome is harsh, if there was a punishment imposed by the court, the consequences follow. So consequences will not stop. However, in this case, the matter went to the Supreme Court, and Supreme Court has given a stay on this particular issue, and probably now it is pending. So this case shows that irrespective of the consequences or harshness of the law, you cannot, interpret it in a different way. Now, there is another case which, I would like to put it here, and this is quite an interesting. M.V. Joshi versus M.U. Shimpi and others. This was a case in which the M.V. Joshi was a butter dealer, okay? And he was convicted for selling butter that was below the prescribed standards. So, under the, food adulteration law, here the Joshi made a submission that I am not producing the butter as you see, like Amul butter or any other butter. I am producing a butter by way of, milk. And it is just like in a house we make butter. So it is kind of a white butter. So it should not be covered in the adulteration law. But the court said that it is not the situation. And it said in this case, the food inspector seized the butter from M.V. Joshi's shop, which upon analysis was found to contain so much of foreign fat, so much of moisture and milk fat, thereby failing to meet the prescribed standards. And it was held that it is a violation. The judicial magistrate initially acquitted Joshi, arguing that butter prepared from curd did not fit in the legal definition of butter. However, the High Court overturned this acquittal and asserting The butter prepared from curd is indeed covered by the definition, and that selling butter below the prescribed standard qualifies as selling adulterated food. The Supreme Court upheld this decision of the High Court and adjusting the sentence from rigorous imprisonment to fine, thereby reinforcing the interpretation that butter made from curd is subject to the same standards as butter made directly from milk or cream. So the fundamental principle of interpretation, namely that the primary test is the language employed in the act, and when the words are clear and plain, the courts are bound to accept it, as the intention of the legislature. There is no further scope of interpretation on that. I hope this point is clear to you. Now we are coming to the rules of interpretation. And before we come to the rules of interpretation, if you have any questions, you can utilize, you can ask me in the chat box. Yes. Yes, Hardik, it may be repealed, but this is an old case law, so 18A is part of that. Okay. Okay. Any other questions? Okay, General Clauses Act, Section 22. General Clauses Act, I have already, you have to go back to the video and see. I've explained General Clauses Act in quite detail, but still for you have asked, it says making of rules or bylaws and issuing of orders between passing and commencement of the enactment. This I have already explained in detail. Okay, what next? Any other question on the points I have taught to you right now? Okay, if there are no questions, let us move ahead and talk about the rules. So as you can see, there are two kinds of rules. One is called primary rules, and the second one is known as secondary rules. In the primary rules, you can see rule of literal construction, reasonable construction, harmonious construction, and then there is rule of Hayden's case, that is called mischief rule. Then we have rule of beneficial construction, rule of exceptional construction. These two rules, beneficial construction and exceptional construction, are not exactly a separate rule, but it is a way of interpretation. So from my perspective, if you look at it, there are only four rules of interpretation: literal construction, reasonable, harmonious, and mischief rule. The other two, beneficial and exception construction, are the ways of construction which court does. I will come to that in a way. And the rule of Ejusdem, generis, doctrine of Noscitur, sociis, and doctrine of Contemporanea, expositio. These are the doctrines which are secondary rules basically. So rule of Ejusdem generis is not a primary rule; it is a secondary rule. Somehow it is mentioned in your syllabus, in your course, as primary rule. So this is which you have to read accordingly. Now let us move ahead and talk about the rule of literal construction. So when I talk about rule of literal construction, it is basically, if you look at the rule of literal construction, the principle of statutory interpretation, the book, it clearly says the intention of the legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. As a consequence, a construction which requires for its support addition or substitution of words, or which result in rejection of words as meaningless, has to be avoided. So while you are reading the provision, you should not skip a word because that suits you. You cannot add a word because that suits you. You cannot use a synonym because that suits you, or an similar kind of a different word which suits you. You have to read the law as it is provided. Okay. So the literal rule, also known as the plain meaning rule, or it is also referred to as cardinal rule or ordinary rule, is a type of statutory construction which dictates that statutes are to be interpreted using the ordinary meaning of the language of the statute, unless a statute explicitly defines some of its terms otherwise. Now, in other words, the law is to be read word for word and should not divert from its true meaning. It is the mechanism that underlines textualism and, to a certain extent, originalism. The Latin maxim absoluta sententia expositio non indicate. This is what literally means an absolute sentence or preposition needs not an expositor. That is, plain words require no explanation. This is what is the literal rule. So, wherever there is a plain word explained clearly, there is no requirement of further explanation of that. Thus, it is primary duty of the court to interpret the words used in legislation according to their ordinary grammatical meaning in the absence of any ambiguity or doubt. Where there is ambiguity, where there are two meanings coming out of the word, you move on with reasonable construction, which we will talk about it just now. So the language of the statute should be read as it is. So what? You don't have to add or substitute a word. Let us take an example. This British India General Insurance Company versus Captain Ibdar Singh. This is the case. And in this, the question in this particular case was basically that what is the scope of defenses available to insurer under section 96(2) of the Motor Vehicles Act 1939. Now, in this case, the court held that insurers cannot challenge the quantum of compensation awarded unless they prove one of the grounds specified under section 96(2) of the Motor Vehicles Act 1939. No additional ground may be added by inserting the word also after the words on any of the following grounds. So you can see the exact statute there, which I have reproduced at the bottom of the slide. So it says no sum shall be payable so and so, so and so. And it is saying on any of the following grounds, comma, namely, and it lists the grounds. Here, the objective of the insurer was that please add also here so that they can include any other ground also, other ground other than the listed ones. So the court reinforced the doctrine that no word should be added or omitted in interpreting statutory text unless absolutely necessary to avoid absurdity or inconsistency. So since there was the statute was very clear, there was no requirement of adding the word also in this. So this is how the statute should be read. You cannot add or substitute a word in the statute unless there is ambiguity. If there is an ambiguity, then definitely for making it workable, the fourth principle, you remember? So for that, you may have to do it, but in general circumstances, you don't have to provide any word or add any word or substitute any word. You have to read the language of the statute as it is. Let us come another example. So if you will see, this is a case of causus omissus. So causus omissus is a situation where there is omission of a term and the court does not. So this case, there was a case of Gladstone versus Bower, and this is the foundational decision in contract law which explores the causus omissus principle, and it says that in case of contract, you cannot add certain things or you cannot provide certain things. You have to interpret it as it is available. So the court in this case, Gladstone versus Bower, held that no words or obligations can be implied into a contract unless it is necessary to give business efficacy to the agreement. The principle applied was that the parties must abide strictly by the words of the contract unless those words lead to an absurdity or fail to achieve the clear intention of both the parties. In this particular case underscores two basic points. One, the literal rule of construction requires interpreting the statute or contract exactly as written. Second, courts should not modify contracts by inserting or omitting terms except in circumstances where the omission makes the contract unworkable or leads to absurd outcomes. Here, there is one infamous case of Rogers versus Alliant, and I would suggest that you people read this particular case, quite an interesting one, where the termination clause was challenged based on a comma. And in this, there was a million, a million of amount of a contract was, honored by challenging it on the basis of a comma. So a comma even in a document can make the interpretation different. However, it is, many a times the courts will not provide the omission which is there in the legislation. It will provide interpretation, but in some cases it does. Like, say, for example, Bangalore Water Supply Sewage Board case. This was the case in which there was an question of interpretation of the term industry under the Industrial Disputes Act. And here the court extended the scope of the statute by interpreting the term industry expansively while acknowledging the omission. So there was an omission and it didn't include water supply. So they said that water supply or system would also be, considered as an industry. And after this decision, you will see Bangalore Water Supply, they expanded the definition of industry so much that a lot of things got included in it. And this was basically beneficial legislation. So we'll talk about beneficial interpretation. So since this dealt with the labor and labor class welfare legislation, so they wanted to include more and more people into the expanse of the definition of industry, so that the benefit of the labor laws can be provided to them. That was the objective. Ideally speaking, if I follow the literal rule, this interpretation may be wrong. But if I follow the welfare rule, then that will be correct. So this is the decision, contrary decision to what Causus omissus says. Now let us talk about another important, in the literal rule, one should avoid rejection of words. So you should not reject a particular word which features there. So every word in a statute is assumed to have deliberately been included in the legislature, and the court should strive to give meaning and effect to all words, avoiding interpretations that render any word or phrase superfluous or redundant. Let us take an example of this case. The state of Bombay versus Ali Gulshan. This is the case, 1955 AIR 810. And in this particular case, there was clause A of subsection 4 of section 6. There, omitting portions unnecessary for our present purposes run in these terms. So they read this: the state government may, by order in writing, requisition the premise of the purpose of a state or any other public purpose, and may use or deal with the premises for any such purpose in such manner as may be appear to be expedient. Here, the validity of the act is not questioned as unconstitutional or as beyond the scope of legislative competence of the state, as the premises were required for housing of a member of a staff of a consulate. There can be no doubt that it was wanted for a public purpose. So the question here was that whether acquisition of a land by the state for consulate's house can be considered as public purpose, and the court said that there is no requirement of rejecting anything out of it, and it can be included as other public purpose. So they said that don't read this other there. So the court said there is no need for that, and other public purpose will include all kind of purposes which the state wants to acquire the land for. So that kind of an interpretation was given in this particular case. So this is the decision which was made in this case. As you can see here, this is the court's decision actually. So it says, in any event, other public purpose is a category distinct from union purpose and state purpose, and the acquisition of requisitioning of property by the state except for the purpose of union is within its competence under item 36 of the state list. So this is the interpretation which court gave in this case. So I hope this is clear to you that while interpreting, there is no need for rejection of the thing. Okay. Now, yes. Now let us move further and talk about another important principles which Cross is the jurist. In his book Statutory Interpretation, he has given some principles, and this principle with reference to literal interpretation is like this, and it says the governing idea here is that if a statutory provision is intelligible in the context of ordinary language, it ought without more to be interpreted in accordance with the meaning an ordinary speaker of the language would ascribe to it as its obvious meaning, unless there is sufficient reason for a different interpretation. Unless there is a sufficient reason for a different interpretation, you go for a literal interpretation. Thus, an ordinary meaning or grammatical meaning does not imply that judge attributes a meaning to the word of a statute independently of their context or of the purpose of the statute, but rather that he adopts a meaning which is appropriate in relation to the immediately obvious and unresearched context and purpose in and for which they are used. By enabling citizens and their advisors to rely on ordinary meanings, unless notice is given to the contrary, the legislature contributes to legal certainty and predictability for citizens and to greater transparency in its own decisions, both of which are important values in a democratic society. So Lord Reed in House of Lords cases said, in determining the meaning of any word or phrase in a statute, ask for the natural or ordinary meaning of that word or phrase in its context in the statute and follow the same unless that meaning leads to some result which cannot reasonably be supposed to have been the legislative intent. Similarly, he said, rules of construction are our servants and not masters, and a statutory provision cannot be assigned a meaning which it cannot reasonably bear. If more than one meaning are capable, you can choose one, but beyond that, you must not go. This is the basic principle of literal interpretation, which has been laid down in the House of Lords cases by Lord Reed. In a number of cases, it is a summary of what Lord Reed had to say. And in Indian courts, we are following similar kind of an interpretation. Now, let us move further and talk about, just a second, I think the presentation has gone heavy. Yes. So rule of reasonable construction. This is the second rule of construction or interpretation. So rule of reasonable construction is also referred to as golden rule of interpretation. This is why it is called golden rule of interpretation, because it is trying to solve the problem. So it is not literal interpretation. Here, many a time situation arises where literal interpretation will lead to confusion. Then there is a requirement of bringing this rule of reasonable construction. So the golden rule of interpretation or reasonable construction is a legal principle that allows court to modify the meaning of a law to avoid absurd outcomes. It's used when the literal meaning of the law is clear, but leads to an unreasonable or unjust result, right? The words of a statute must be construed ut res magis velet quam perit, meaning thereby the words of statute must be construed so as to lead to a sensible meaning, right? When a grammatical interpretation leads to a manifest absurdity, then the court shall interpret the statute so as to resolve the inconsistency and make the enactment a consistent whole. This principle is based on the rule that the words of a statute must be construed reasonably so as to give effect to the enactment rather than to reduce it to futility. So objective is that law should be made workable. You remember the basic principle, one of the basic principle, that the law has to be made workable. You cannot just leave it. So that is the principle. So the principle is contained in the Latin maxim, interpretatio fienda est ut res magis velit quam perit. In short, statutes should be construed grammatically. So this is what, now I will give you an example of this. And this is the famous case of Alder versus George. So this is a case, this is of English public law case that exemplifies the application of golden rule of a statutory interpretation. The golden rule allows judges to depart from the literal meaning of the word in a statute when adhering it to would lead to absurd or inconsistent results. So this case basically involved interpretation of the Section 3 of the Official Secrets Act of 1920. So what is the Act said? Act said that there was an offense to obstruct Her Majesty forces, that is RAF forces, and a prohibited RAF forces in the vicinity of a prohibited place. Okay. So here in this case, the defendant entered the RAF station. So that was a prohibited place under the Act. But when he was caught, he argued and he said that he was not in the vicinity of the station. That is the light blue area. The dark blue area was the RAF station. So he said that I was in the prohibited place and not in the vicinity of the place. So he said that you read it literally, in the vicinity means nearby, not inside. So the key issue was whether the defendant, by entering the RAF station, violated the terms of the act or not, given the literal interpretation of the term in the vicinity. So now people may be thinking that how stupid people are on these particular points. Also, they make an argument. But see, House of Lords has to make a decision in this particular case. They have to discuss. The Queen's Bench discuss this, and in the High Court, the defendant conviction was upheld under the golden rule of statutory interpretation. The court applied the golden rule to avoid an absurd outcome and extended the meaning of in the vicinity to include in or in the vicinity of. So see how the interpretation works. In this case, Lord Parker CJ emphasized the potential absurdity in strictly adhering to the literal rule. He stated that it would be extraordinary and absurd if an indictable offense was created when obstruction occurred just outside the precincts of the station, but in the vicinity. On the other hand, no offense would be created if the obstruction occurred directly on the station itself. The judge's use of the golden rule allowed for a more reasonable interpretation that aligned with the broader purpose of the statute. So I hope this clarifies your idea about the golden rule or reasonable construction. So this is reasonable construction. There is another rule of construction that is called harmonious construction. So many a times what happens that there is a conflict between two provisions of the statute, or there is a conflict between the provision of the statute and the object of that particular legislature. So when there is conflict around that, there is a requirement of a harmonious construction. So it is a basic rule of interpretation that if it is possible to avoid a conflict between two provisions on a proper construction thereof, then it is the duty of the court to so construe them that they are in harmony with each other. A specific rule will override a general rule. This principle usually is expressed by the maxim generalia specialibus non derogant. So wherever there is a special rule, they will override the general rule. If you see, let us take an example: environment regulations versus economic development. So you will most of the times find a conflicting opinion around it, right? So if on one hand the law protects the environment, while on the other hand, it encourages economic development in the same area. The court can use harmonious construction to balance these two laws. And it has done that in a number of cases. As you will see, Goa Foundation versus Sesa Sterlite, Goa mining case. You talk about Mopa Airport case, Sterlite copper plant case, sand mining cases, NCR construction ban case. These are the different cases in which a harmonious construction rule was utilized by court to find out to harmoniously, balance two kinds of legislation. In most of the tender cases, wherein the economic, which is challenged under Article 14, the courts have given a leeway on public policy grounds to the government to have a policy on a particular area or to come up with a tender if it is not breaching the Article 14 of the Constitution. So this is rule of harmonious construction. In one of the cases, the Supreme Court, particularly the Commissioner of Income Tax versus Hindustan Bulk Carrier, laid down the following principles to govern the doctrine of harmonious construction. So what the court said? It said, while interpreting the provisions, the court needs to avoid all circumstances of head-on clash between the provisions. They must be construed harmoniously. Interpretation by the court should be done in such a way that one provision does not defeat the other provision unless there seems to be no possible construction. If the situation is so that it becomes impossible to reconcile the provisions in conflict, the courts must decide in such a way that both provisions are given effect. Any construction that renders one provision of the statute useless or dead letter should not be given effect. Such construction is not a harmonious construction. A harmonious construction is one which does not defeat any other provision. There is another example, Kerala Education Bill case. In this case, the Supreme Court held that in deciding the fundamental rights, the court must consider the directive principles and adopt the principles of harmonious construction. So two possibilities are given effect as much as possible by striking a balance. So the courts try to come up with a balance, and that is called harmonious construction. Now, there are a number of elements, and many a times when you are talking about reasonable construction, literal construction, or harmonious construction, you have to refer to the subject and object of the law. Let us take another example, UP Bhudan Yagna case. So this case was, I don't know whether you people are aware, but Bhudan Yagna Act 1953 actually enabled the government to acquire certain land and give it to the landless persons, landless people. In this case, some businessmen, local businessmen wanted the land under the Bhudan Yagna case, Bhudan Yagna Act, stating that they didn't had any land. So the Supreme Court, while interpreting this particular provision, went to the object of the law and found out and said that objective of this particular law was to give the land to the landless person eligible for it. And these were the landless peasants, landless people, and not someone who didn't had land. Just so it held that mere lack of formal land ownership was not enough. Landless person should also demonstrate an economic need for the land consistent with the welfare of the objective of the act. Similarly, you will see this have produced this statement and objects of reasons of one nation, one election. And see, this is the statement and objects of reason. When you read this statement of objects and reasons, you come to the idea that what is the intention of the legislature. Right now, this law is yet to be passed. It is under the Joint Parliamentary Committee. It has gone, but there are reports which has come up. And the constitutional amendment, 129th constitutional amendment, was brought in Lok Sabha, and it has now been sent to JPC for further examination. But you see the objectives. They have given the objectives here, why they want one nation, one election. And this particular objects clearly say that. It says general elections of House of People and all legislative assemblies were held simultaneously during this period. However, subsequently, because of premature dissolution of some legislative assemblies, the cycle was disrupted. And further, the Law Commission has, in such and such report, given the suggestion that there should be simultaneous elections and like that. So this is what is the object. So whenever there will be a provision which requires to interpretation subsequently, then they will come back and see what is the object of the legislation. Okay. So in interpretation, object of the legislation also becomes an important element. Though this objects, statement of objects and reasons, or you can say parliamentary debate, are external aid to constitution, we will come to that in a later point in time. Now, in your course material, they have also used these terms, subject to, notwithstanding, and without prejudice. But before I move into this, any questions so far? Any questions you people have? I'll be happy to answer. Conjuncture is basically doubt. Decision based on conjunctures. That means decision based on hunch. Now, let us, you must be now noticing that the basic structure of basic principles are applicable in all these rules of interpretation, right? So say, for example, intention of the legislature. What are you doing in literal interpretation or harmonious construction or mischief rule. All these rules, you are trying to find out the intention of the legislature, right? So that is the principle which is applicable to everyone. Then it says plain meaning should be given the effect. So that is basically literal construction. But if you see the other one, it says that the legislation has to be made workable. That is where you come with golden interpretation. You come with reasonable construction. You come with harmonious construction, mischief rule. You come from that particular angle, right? So this is how you relate the basic principle and the rules of interpretation. Okay. Let me check the portal also if there are any questions. Questions there? Any other questions here? Any one of you? Okay, now let me take you to these points. Okay, so when you are talking about harmonious construction and the construction, there are some cases where you will find in a statute some clear indications about interpretation. How do you interpret them, right? Like, for example, they use the word subject to, notwithstanding, without prejudice, and it has got certain meaning and objective. So let us begin with subject to. So whenever there is a word used subject to, that basically it is used in a provision, then you have to say that the same subject matter is covered by that provision and by another provision or enactment subject to which it operates, and there is a conflict between them, then the latter will prevail over the former. Let us have an example. Section 13(2) of the Companies Act 2013. So it says any change in the name of a company shall be subject to the provisions of subsection 2 and 3 of section 4 and shall not have effect except with the approval of the central government in writing. So what it is trying to tell you, that you can change the name of a company, but that is subject to section 2 and 3 of subclause 4 and shall not have effect without the approval of the central government. So this is making the provision section 13(2) constricted. It is not a broader application. It is subject to the provisions which have been mentioned with reference to that, right? When we talk about without prejudice, so without prejudice basically means without referring to that or without mentioning that. So when certain particular provisions follow general provisions, and when it is stated that the particular provisions are without prejudice to those general provisions, the particular provisions would not restrict or circumscribe the operation and generality of the preceding general provisions. So in other words, you can say the particular provisions shall operate in addition to and not in derogation of the general provisions. So if I can say, without prejudice to my legal right, I would like to try mediation. So what I'm saying is that just going for mediation will not take away my right to legally challenge that particular issue in court. So this is called without prejudice. So without prejudice is a situation wherein an option, you have the provision gives you an option other than the general provision. So you say without prejudice to the general powers given to by without exercisable by an authority they are being given these specific powers. So this is what without prejudice means. Now, notwithstanding is a word which you will find many a times, and it is called non-obstante clauses. And non-obstante clauses are there. Basically, begins with the word notwithstanding anything contained, and unlike the subject to clause, the notwithstanding clause has the effect of making the provision prevail over others. So here, what if a word notwithstanding is used, it will prevail over the other words. So it says notwithstanding so and so, this will be done like this. So if I say notwithstanding my previous arguments which I made, the argument made in this particular slide prevails. That means whatever I have said so far will be subject to, or you can say will be giving way to the present slide. This is what notwithstanding means. So let us take some more example. If you see your course material, they have talked about four type or four levels of notwithstanding clauses. So if you have a look at them, the first one says notwithstanding anything contained in another section or subsection of that statute. So for example, section 42 subclause 11 of the Companies Act talks about this, and it says notwithstanding anything contained in subsection so and so, subsection so and so, any private placement issue not made in compliance of the provisions of subsection 2 shall be deemed to be a public offer, and all the provisions of this act and securities so and so shall be applicable. This is what it is trying to say. So what do you mean by notwithstanding here? Here, basically, it says whatever is said in subclause 11 will be prevailing over the provisions mentioned in subsection 9 and subsection 10 of the provision, right? So they may have said something else there. So those things will not apply to section 11, right? Subsequent one, second is notwithstanding anything contained in a statute. So it says section 8.8 of the Companies Act. It is saying amalgamated with another company registered under this section and having similar object, then notwithstanding anything contrary contained in this act, the central government may by order. So you see, it is saying basically the whole act as notwithstanding. So you are saying basically whatsoever has been said in this particular act, what is mentioned in section 8.8 gets a precedence over the anything which is mentioned in the act. So this is what basically the second level says. Third level is notwithstanding anything contained in specific sections or subsections or all the other provisions contained in another statute. So here they are referring to some other statute. Like say, for example, section 7A of the Securities Contract Regulation Act. So here what is the legislation? Securities SCRA. Here they are saying, and on such publication, the rules as approved by the central government shall be deemed to have been validly made, notwithstanding anything contained in the Companies Act 1956. So Securities Contract Act is referring to the Companies Act and saying whatsoever has been mentioned in the Companies Act, that is not going to affect what we are saying here in section 7A. Similarly, section 183 of the Companies Act, what it is referring to, it is saying the board of directors of any company or person or authority exercising the power of board of directors of a company, so and so, so and so, and it is referring to National Defense Fund or any other fund approved by the government. So it is saying without notwithstanding anything contained in that particular provision, it will not be applying here. So notwithstanding anything contained in any other law for the timing in force. So you can see here section 8 of the Securities Contract Regulation Act, again referring to Companies Act 1956. I believe notwithstanding clause is clear to you people. So it is basically saying that notwithstanding anything here, in this particular law, this provision will prevail. So this is the idea which this notwithstanding clause or non-obstante clause talks about. Yes, Kiran Kumar, your point is right. If there are two non-obstante clause, then always the basic principle of interpretation is the latest one prevails over the earlier one. Now, let us talk about the mischief rule. And this rule is also referred to as rule in Hayden's case. So, this is a case which is quite interesting, and it is of 15, again, the British period, and the case from UK. So, this case basically involved lease, life estate, and statutes. So, in UK, at that point in time, you may be knowing that there were two parallel powers which were working. One was the church, and the other one was the king, right? So at that point in time, the church had a lot of property, a lot of lands they had, and they used to give this particular land by way of a copyhold to different people. Okay? So they will give it to peasants, they will give it to fishermen, and they will give a copyhold. Copyhold was kind of a copy of the sale deed, you can say. The main original document would remain with the church, and they would give a copyhold for life. This copyhold will entitle the person concerned to hold that particular land for life. In this case, what happened is that the king wanted that the church should get less power, and they tried to come up with the law through parliament. They enacted Suppression of Religious Houses Act 1535, which basically said that all these particular leases and everything will be, land which is there with the churches will vest now in the parliament, or you can say the state, and those leaseholds which have been given to people 1 year beyond 1 year, within the last 1 year, beyond 1 year will be going as it is, but anything which has been done in the last 1 year, then that will be not correct. So in this case, what was happened that this particular law came up in 1535, and the land which was given to this where the son and where the father, from them the land was taken by Ottery College, and it was given to one Hayden. So Hayden was given, and this was within the 1 year period which the Suppression of Religious Houses Act mentioned. So the court, while interpreting this, it applied it tried to correct the mischief, and it saw that what is the objective here. The court held that the transfer of land from the original father and son to Hayden was with an objective to evade Suppression of Religious Houses Act, and that is not correct, and that was not the intention with which the legislation was brought up. And in this, Lord Coke brought up this interpretation for the first time, and this was referred to as mischief rule. And he said, for sure and true interpretation of all statutes in general, be they penal or beneficial, restrictive or enlarging of the common law, four things are to be discerned and considered. First, what was the common law before the making of the act? Second, what was the mischief and defect for which the common law did not provide? Third, what remedy the parliament hath resolved and appointed to cure the disease of the commonwealth? And fourth, the true reason for the remedy. And then the office of all the judges is always to make such construction as shall suppress the mischief and advance the remedy, and to suppress subtle inventions and evasions for continuation of the mischief, and pro privato commodo, and to add force and life to the cure and remedy according to the true intent of the makers of the act pro bono publico. This is what has been talked about in the Hayden's case, or you can say the mischief rule. So I feel that this rule is quite interesting one, where you can apply it irrespective of the mischief. You can apply it in general interpretation clause also. So I feel, this is what is my view, that the laws are there to cure some mischief, and you have to find out the objective with which the law has been made. However, there are interpretations in this, and let me give you some examples from our Supreme Court on mischief rule, and then I will talk about the critique. So one of the examples which is given in your course material talks about application of this mischief rule is too well founded on construction of Section 2F of the Prize Competition Act. So this section defines prize competition as any competition in which prizes are offered for the solution of any puzzle based upon the building of arrangement, combination of permutation of letters and figures, words and figures. The issue in this case was whether the act applies to competitions which involve substantial skill and are not in the nature of the gambling. So Supreme Court, after referring to the previous state of law, to the mischief that continued under that law, and to this resolution of the various states under Article 252, authorizing Parliament to pass an act, stated as follows. It said, having regard to the history of the legislation, the declared object thereof, and the wording of the statute, we are of the opinion that the competitions which are sought to be controlled and regulated by the Act are only those competitions in which success does not depend on any substantial degree of skill. This is RMD Chamarbagwala versus Union of India. It's a very famous case where mischief rule has been applied. Similarly, in another case, Kanai Lal Paramnidhi, the Supreme Court held that observation made by the Chief Baron and Baron's Exchequer have so frequently been cited with approval by the courts administering provision of welfare enactments that they have now attained the status of a classic on the subject and their validity cannot be challenged. So mischief rule is very much ingrained in our interpretation framework of Supreme Court. So in CIT versus Sodra Devi, court said, but the mischief rule can be applied only if there is an ambiguity in the present law. In every situation, you cannot apply the mischief rule. When literal interpretation can be given, then there is no requirement of a mischief rule. This is an additional material which some of you, if you want to read, you can read. This is critique to mischief rule, basically, and it says from an US perspective, the author claims that mischief rule is of not much use because nowadays the statutes are not only meant to cure mischief, but they are there to prosper the future, or they are there to look at the future issues or future concerns. So hence there is no, and there are many a times statutes are created to create a framework of agencies. Like for example, Competition Commission of India is brought into force, or maybe NFRA is brought into force. It is not necessary that they may be there for curing some mischief. So this is the critique which has been given. So I leave it to you for just for reading purposes. It is not part of your syllabus. You will not be told to read this book. But if you have an idea, then you can write few lines on that. Now, before I move to the other clauses, any questions you have? Okay. So today we are not taking the break, basically. So I will complete it. And whenever it completes, that is the break after that. Okay. Yes. Any questions you have till this point? If you have any questions, then we can. Okay. So mischief rule, when we talk about, basically mischief rule is a law which is coming from this Hayden's case. I hope you understood the Hayden's case. I have given you one small video also. YouTube link is there in this slide. You can click to this YouTube link and try to see this video. There's a small video of 5-7 minutes, which explains this in a very good caricature way. That will explain it further. But for your understanding here, this video is about Hayden's case. So if you go through that case, you will understand it clearly. Mischief rule, basically in common language, it says that whenever you are interpreting a law, you go back and find out what is the mischief, because any law which comes up must be curing some mischief or some problem, right? So while interpreting the law, you have to find out what was the law before that particular law which you are interpreting. Say, for example, you are interpreting X law, okay? And you have to find out what was the position before the X law came. This is one thing which you have to find. Second, what was the objective of bringing this X, what kind of a mischief it was trying to cure, and what kind of a remedy it has given to cure that mischief. That is what you have to see. And what was the true reason for that particular remedy? What was the objective of giving that remedy? These four things you come to know, that is what is mischief rule. And then you interpret that particular provision. This is how mischief rule works. Okay. Now, let us look at the concept of beneficial construction. So there is a beneficial construction. Strictly speaking, as I told you before, this is not a rule, but a method of interpreting provision liberally, so as to give the effect to the declared intention of legislature. Beneficial construction will be given to a statute which brings into effect provisions for improving the conditions of certain classes of people who are underprivileged or who have been treated fairly in the past, unfairly in the past. In such cases, it is permissible to give an extended meaning of the words or clauses in enactments, but this can only be done when two constructions are reasonably possible and not when the words in a statute are quite clear. So this beneficial construction can only be given when there are two meanings possible. If the meaning is clear, no benefit has to be given. You cannot extend benefits, right? Now, let us look at this beneficial construction. One of the cases, this is alembic chemical work versus workman. Here, an industrial tribunal awarded more number of paid leaves to worker than what was mentioned in section 79(1) of the Factories Act. This was challenged by appellant. Supreme Court held that enactment being welfare legislation for the workers, it has been beneficially constructed in the favor of the workers, and thus, if the words are capable of two meaning, the one who gives benefits to the workers should be used. This is what court said. And in most of the labor law cases, courts gives a beneficial construction to the workers. Second, Tolaram versus State of Bombay. This is a penal statute or criminal law. The court observed it is a well-settled rule of construction of penal statutes that if two possible and reasonable construction can be put upon a penal provision, the court must lean towards that construction which exempts the subject from penalty rather than the one which imposes a penalty. So this is what was held in Tolaram versus State of Bombay. So this is how the penal statutes are. So if there are two constructions possible, one construction which favors the accused, that will be taken into consideration. You must have all read about the RG Car case, the Calcutta one. The RG Car case, the sentence has been come up, and the death penalty has not been given in that case. There is a lot of hue and cry in social media. You must be seeing. And similarly, there is another case in Kerala wherein death penalty was given to a woman, and people are comparing this. So you have to see that what kind of an interpretation the judges have given. I don't have the order, but I have gone through the RG Car decision, and they have given this beneficial construction to the accused in that particular case because evidence, they have looked at the evidence and all those particular things, and then they have given that decision. So you have to see that wherever there is a beneficial construction for a particular and of labor law, labor connection will also be labor space also labor law provisions socially interpreted in favor of the labor. There is one provision under the Constitution, that is Article 21 of the Constitution of India. Interesting, So Article 21 of the Constitution of India says no person shall deny of his life or personal liberty except according to the procedure established. So see, this is such a one-line article, but you'll be surprised to know that Supreme Court has interpreted so many provisions, so many rights to the citizens of the country. They have been able to give these particular rights under the Constitution of India by giving the beneficial construction. So they have interpreted the term personal liberty and life elaborately, and they have said that the meaning of the life is something which includes, jobs. It includes So that is something which has been, expanded. So this is quite an interesting uh, framework which you can have a look at. Okay. Now let us talk about rule of exceptional construction. So this is also mentioned there in your book, and it talks about reasonable construction. When you talk about what is reasonable construction is the words of a statute construed so as to give a sensible meaning to them if possible. They ought to be construed at res magis valeat quam perit. It is better for a thing to have effect than to perish, or that the matter may have effect rather than fail. This is what is the objective of the law. Now, when we talk about exceptional construction, this is a principle of a statutory interpretation which is used to interpret statutes in a way that deviates from the usual rules of interpretation. This principle is used when the usual rules of interpretation, such as plain meaning rule or mischief rule, will lead to an unjust result. Let us take an example. In Maharaj Singh versus State of UP, this case, an exception to the same word, same meaning principle was made. So there is a basic principle in, there is a principle of interpretation which says word will mean similar meaning throughout the statute. You cannot differentiate unless there is a specifically it is said that this word has this meaning. Okay. And in this case, there is an exception to this principle, same made by interpreting the word West, V-E-S-T, West, as used in UP Zamindari Abolition and Land Reform Act. So when land and markets, that is Hearts and Bazaar, vested in the state, the word connoted absolute ownership, effectively extinguishing the proprietary rights of Zamindar, right? But when the same word vested was used in the context of Gram Sabha, the term implied a transfer of administrative control or possession for local governance and public use and not full ownership. So you see the same word West, when it was read with state, it was full ownership. When it was read with Gram Sabha, it was only for usage. It was not a full ownership. So Gram Sabha cannot sell that particular land or give it to somebody. Okay. I hope this distinction you are able to understand. This is an exceptional construction where the same word in the statute are giving different meaning by way of a construction. Now let us talk about another important rule, and that is called conjunctive and disjunctive words. So there are two kinds of words. One is called conjunctive and the other one is called disjunctive. And is a word which is conjunctive word, which basically joins. And or is a word which is a disjunctive word, which basically disjoins two provisions. So the word or is normally disjunctive and is normally conjunctive. However, by way of an interpretation, sometimes the courts may interpret it one or the other. So and can be read as or can be read as and. Now you people may be thinking what kind of a confusion these lawyers have created. But this is how the interpretations are, because many a times when the parliament makes the law, they are not, many a times they miss this particular word, or you can say they intend something and that is not, draftsmen probably miss certain things, and that has to be curated, okay, in interpretation. So in this particular case, there was one case, Professor Yashpal versus State of Chhattisgarh. The expression was established or incorporated, used with reference to section 2F, 22 and 20 of the Grants Commission Act, that is UGC Act. This was read by the court as established. Instead of or, they read and. Because if they would have read or, the universities would have said, we are established, though it was not incorporated. So here they said that established should be with and. They are conjunct, not disjunctive, having regard to the constitutional scheme, and in order to ensure that the act is able to, UGC is able to perform its duties. So this Professor Yashpal case talks about that. Second case is about Ishwar Singh Bindra versus State of UP. Now in this case, the expression substances in the definition of drug contained in section 3b meant something other than medicines. And here the word and used in the definition of the drug between medicines and substances is to be read disjunctively. Here they said medicines and substances, they cannot be read together. It has to be read differently, and they used the word or instead of and. And while referring to Stroud's Judicial Dictionary, this court said, and has generally a cumulative sense requiring the fulfillment of all the conditions that it joins together. And here is antithesis of all. Sometimes, however, even in such a connection, it is by force of a contents read as or. Similarly, in Maxwell on interpretation of the statutes, 11th edition, it has been accepted that to carry out the intention of the legislature, it is occasionally found necessary to read the conjunctions or and one for the other. This is what was held in this particular case. So you saw how and can be used as or can be used as and, but not in normal circumstances. You have to be finding out the exceptional circumstances. Now let us talk about another important thing, that is mandatory and directory provisions. So in law, you will have mandatory provisions and directory provisions. Most of the times will be may and shall. This we also saw in our General Clauses Act, and I will repeat those slides briefly. But in one of the cases, Punjab National Bank versus Ghulam Dastagir, the statute stated that the landlord may apply to the court for eviction of the tenant in certain circumstances. Here in this case, the Supreme Court said, in this context, may imposed a duty, not a discretion, on the landlord to apply for eviction under the specific circumstances. Because if you use the word may here, may, if you don't want to apply, don't apply. But if you want to have a relief, you shall apply. So this was interpreted as shall. Leaving the discretionary would defeat the statute's purpose for protecting landlord rights. In case of State of UP versus Manbodhan Lal Srivastav, here they were interpreting Article 3 of the Constitution, and that it shall be duty of the Union and state public service commissions to advise on disciplinary matters. Here the question was whether consulting the Public Service Commission was mandatory or merely directory. So court here held that the use of the word shall, the provision and mandatory. This interpretation ensured administrative decisions were not invalidated solely due to non-compliance with the advisory requirement. So this is how the interpretation happens. The use of word must in place of shall will be sufficient to hold that the provisions are mandatory. So wherever you find the word must, that is of no further interpretation is required for whether it will be may or shall. It is must. Shall with respect to one matter and the use of word may with respect to another matter in the same section of the statute will normally lead to a conclusion that the word shall imposes an obligation, whereas the word may confers a discretion. But that by itself is not decisive, and the court may, in regard to the context and consequences, come to the conclusion that the part of the statute using shall is also directed. This is what G.P. Singh said in the statutory interpretation book. And I dealt with this particular provision when I was teaching you General Clauses Act. I request you people to again look at the General Clauses Act for that purpose. So these are the things which we have already discussed before, right? Now, let us talk about the subsidiary rules, or this is part of preliminary rule in your case, but this is rule of Ejusdem generis. So rule of Ejusdem generis basically says where specific words pertaining to a class or category or genus are followed by general words, the general words shall be construed as limited to the things of the same kind as those specified. So whenever there is a statute which has enumeration of specific words, say for example, it says the following things and it lists A, B, C, D, E, then you have to read all these provisions together. You cannot read them as different. Like let me give you an example. So if law lists automobiles, like trucks, tractors, and motorcycles. Here, the general term, under the general term vehicles, you will be interpreting them not to include airplanes. So airplanes cannot be included here, right? Though it is also a vehicle, but under the term vehicles, you cannot include airplanes, wherein the list says trucks, tractors, motorcycles. Similarly, in case of animals, if the list says dogs, cats, and other animals, the general term other animals would be interpreted to mean similar kind of animals like dogs, cats, not birds and fish. I hope this clarifies the rule of Ejusdem generis. So this rule applies when the statute contains enumeration of specific words. The subject of enumeration constitutes a class or a category. That class or category is not exhausted by the enumeration, and general terms follow the enumeration, and there is no indication of a different legislative intent. When all these five factors apply, rule of Ejusdem generis applies. Okay. Uh, Other than this, there are other secondary rules of interpretation also. And one of the rules of secondary interpretation is doctrine of SOC. So this particular meaning of this word Noscitur SOC is basically the word meaning of a word is to be judged by company it keeps. So to enumeration basically means listing. Okay. So you have to list. So that is called enumeration. Lord Macmillan said this that Lord Macmillan said that the word is to be judged by the company it keeps. So associated words take meaning from one another under the doctrine of Noscitur a soci. So fresh orange juice is not a fruit juice. This is the term. So while dealing with the Purchase Tax Act, which used the expression manufactured beverages, including fruit juices and bottled waters and syrups, it was held that the description fruit juices as occurring therein should be construed in the context of the preceding words, and that orange juice, unsweetened and freshly pressed, was not within the description of the fruit juice. Because if you see, there were manufactured beverages, including fruit juices and bottled waters and syrups. So it was talking about processed juices, not fresh juice. Similarly, there was another example which you can see, which is there in your is private dispensary of a doctor is not a commercial establishment. So of commercial establishment under the Bombay read commercial establishment means an establishment on any business, trade, or profession. The word profession was construed with the associated word business and trade, and it was held that private dispensary of a doctor would not be a business or trade, and then they excluded that. In another case, Pradeep Agarbatti versus State of Punjab, they were talking about the term perfumery, and this was along with cosmetics and toilet goods. So applying this particular provision, it was said that word perfumery in this context will not include dhoop and agarbatti. Dhoop and agarbatti will not be considered as perfumery. Give me a second. Well, hi everyone. That was a bit urgent call, which I had to take. So by force, you got a break of 2-3 minutes. Now let us talk about this. But before I move on to this, further, any questions so far? Any questions? Any clarifications you have? Any points which you feel requires more? Any further explanation? I'll be happy to give that. Anything which you feel like which requires uh, further explanation. I've answered almost all your questions, which you have put in the chat box. Give me a go ahead if there are no questions. Just write no questions. Yes, exceptional construction. When we are talking about the exceptional construction, is basically as an exception, right? So you will see the how the flow goes. Flow of your construction should be literal construction first. If by way of literal construction you are not able to interpret, there is some confusion, you move to the reasonable construction. In reasonable construction, this is the golden rule. You make the construction, but still, if you find that there are two provisions which are conflicting, or the object of the legislation and the provisions are conflicting, then you try to bring a harmonious construction. Even if you are not able to do it by way of a harmonious construction, you move to mischief rule. There you basically see what has been happening in the past, why the law came up, what was the objective of the law, what law is providing, whether that provision is being done properly or not. This is something which you have to clearly mention there. This becomes your overall perspective of the rule. I hope this clarifies your point. Okay. Notwithstanding, okay, I'll come to that notwithstanding once more. No, anything else? Okay, fine. Now, let me take you to the other provision here. There is another doctrine which is called doctrine of Contemporanea expositio. Okay, so this doctrine is based on the concept that a statute or a document is to be interpreted by referring to the exposition it has received from contemporary authority. So here the maxim contemporanea expositio est optima et fortisania in lege. This is what is the maxim. It says contemporaneous exposition is the best and strongest in the law. So what is this saying? In simple language, it is saying that you have to see what is happening, the contemporary things. So this means the law should be understood in the sense in which it was understood at the time when it was passed. So you have to see when the legislation was passed, what was the objective it sought to achieve. So if you have a legislation which was passed in 70, see and conceptualize that particular area when you are looking at the circumstances under which the law was passed. And accordingly, you have to interpret the law at present. So say, yeah, and I'll give you a beautiful example. So Indian Penal Code, 1800s, the law was, okay, 1860. And we were interpreting that particular law till this point, right? When Bharatiya Nyaya Sanhita came up. So do you think that the law was applied as it was there in 1800s? No, it was applied with the present context. But whenever there will be an interpretation which was brought up, we were trying to see that this law meant this at that point in time, but now at present, this law has to be applied like this. Okay? So the maxim optima legum interpres at consulate is the best interpreter of law. So you look at the customs also in many a times while interpreting. Thus, the court was influenced in its construction of a statute by Anne by the fact that it was that which has been generally considered as the true one for 160 years. But this maxim you have to, only apply in case of ancient and contemporary statutes doesn't require this maxim to be applied. To my understanding, this maxim has not very much meaning for you people, but still, since it is mentioning, you have to just remember the meaning of this particular maxim. So, maxim basically says that whenever you are reading the law, you have to see that the law is in the context. Like, say, for example, when you are interpreting Constitution, so you go back to the Constituent Assembly debates, you find out what the maker of the Constitution tried to, why they brought this particular provision. Okay, so that this is basically expositio. Other than this, there are some other rules which I wanted to touch upon, like legal fiction. So this is not there, part of your syllabus. But you will find in many of the legislation, there is a deeming provisions. So these are legal fictions which are created. I'll give you one example. In Competition Act, if a combination provision is there, if you don't, if the commission does not pass the combination decision within 200 days, it is deemed to be approved, right? So this is a legal fiction which is created. Similarly, legal fiction of artificial entity is also created. That is also a legal fiction. Okay. So these have to be interpreted accordingly. Then there is affirmative and negative words which can be utilized. So this is again, many a times you will find the affirmative words and negative words. So whenever there will be a negative words, these are more emphatic. So say, for example, a statute begins, no transfer shall be valid unless approved by the collector. That means it is a mandatory requirement. You cannot discount this. Whereas in case of affirmative language, there may be some scope of relaxation. But in whenever a statute or a legislation is negatively worded, it is mandatory requirement. Then there is something which is referred to as last antecedent. So it basically says that whenever there are more number of terms mentioned, then in that situation, you have to refer to the last word, not the previous word. So let us take an example. So this example says a tenant may install flooring, curtains or furniture made of wood. So here comma is there after curtains and and then furniture made of wood is there. So made of wood, you have to read with furniture and not with curtains, floorings. You have, because it has to be as per the rule of last antecedent. So these are some of the rules. If you see the interpretation, there are many other rules also like this which are mentioned. So this is what was there in terms of the rules. We will also talk about the internal aids and external aids in our next class, that is on Monday. Okay. So I would suggest read some legislations that will give you more understanding about them. Now let me take to the question. I think one of the questions was with reference to, let me bring that. Okay, it was with reference to notwithstanding clause. Okay. So as you are able to see here, notwithstanding basically is the meaning. Notwithstanding का मतलब ये होता है कि it is also referred to as non-obstante clause, and it says that notwithstanding anything which is mentioned, either it can be the same section, it can be same subsection, it can be the act itself, it can be any other act also. So this is what is the different types which are mentioned here. So it is saying, say for example, your first example, it says section 42(11) of the Companies Act, notwithstanding anything contained in subsection 9 and subsection 10, any private placement issue not made in compliance with the provisions of subsection 2 shall be deemed to be a public offer, and all the provisions of this act and Securities Contract Regulation Act, the Securities Exchange Board of India. So here it is basically saying that irrespective of the fact 9 and 10, the private whenever there is a private placement issue has to be is not made within the compliance of this particular provision, it will be considered as a public offer. So this is what non-obstante clause says. Nothing whenever there is a term which is notwithstanding, it basically says that whatsoever has been mentioned around this particular provision will prevail over anything which is notwithstanding. This is how this works. Yes. Now let us talk about Sabah Shakil talks about Noscitur a sociis. So when we talk about Noscitur a sociis, just a second. Yes. So Noscitur a sociis basically says that wherever there is a word, there are more number of words, you have to read the words as per the company it gives, right? And I gave you the example here that in this example, fresh orange juice was not considered as a fruit juice. Why? Because here the manufactured beverages, including fruit juices and bottled waters and syrups, talking about canned waters or canned processed material. It is not fresh natural juice. And hence, fresh natural fruit juice was not included in this particular definition. I hope this clears your doubt. Sabah. Okay. Any other questions? Okay. Optima legum interpest est consulate basically means that custom is best interpreter of law. So it basically says it gives prevalence to the customs. So many a times in ancient laws, particularly say for example, you are talking about Hindu Code Bill or Hindu Marriage Act, there you refer to customs. Like one of the custom that is called Saptapadi is recognized in the Hindu Marriage Act. So that is the best interpreter of law. This is what this magazine says. Understand this Contemporanea expositio and this maxim relates to only ancient laws, not the modern contemporary laws. Okay. Anything else? Okay. If there are any questions, I'll just unshare the screen so that you people can ask me questions. Any questions, any clarifications you have? Yeah. Let me check a few more questions if you have in admin panel. Okay. Richa, you had a question on without prejudice. Without prejudice basically means you know it is kind of an exception, you know. So when you say without prejudice to the rights, you can engage into mediation. That example I gave you. So this is uh, what it says. Okay. So any other questions which you have?
Uh, uh, Good evening, sir. Can you listen to me, sir?
Yes, yes, yes. Go ahead.
Oh, sir, there are the case study. There, how to read that the Air 1969 and the their SC 296. Their words are given. So how to read their case study?
Okay, thank you for that particular question. That's a good question. So see, these are all citation and reports. Okay. So you will see there are different types of reports which are there. So they published in different reports. Nowadays, Supreme Court has started its own uniform citation. Okay, wherein you will see 2004 INSC. So generally, these citations refer to the year of publication when the that is the year. So in most of the citation, you will find the year. This year is not of the judgment, but the year in which it gets reported. Okay. And then you find the journal name. So, for example, it will be AIR, that is All India Reporter, where you will see SCC, that is Supreme Court cases. Many places you will find live law, that is live law. Then you will see INSC, that is Indian National Case Reporter or Supreme Court Reporter, something like that. SCR, Supreme Court Reporter. So these are the reports or journals. And then thereafter, you will find the pages. So page number on which it is reported. This is the way to find that particular decision in the journal. I hope you got the clarity. So you don't have to remember the
Yes,
complete case. In any lawyer who has to cite the case to the court, he will just say AIR 1995 Supreme Court SC 71755. That means in the library, they will go find out the AIR 1995 volume, pick it up, go to page number 1777 and find that particular case. Is it clear?
So, sir, don't written the exam there in a full form. They're only written the names and versus the state of their name.
No problem. So you don't have to write the full citation. See, this is meant for practicing in the court. And if you don't remember that particular citation, there is no problem. Your marks won't be deducted unless there is a specific question on citation.
Okay, sir. Thank you.
Yeah. But remember the name of the parties. Some major cases you should remember the party name, the facts. Like for example, Hayden's case. So you should remember that is Mischief rule case. This is the famous case, very important case. So you should remember that. Okay. Latin words are all you have to memorize it. So Hardik, there's no other way to do it. So certain which when by way of regular usage you remember also, but I also don't remember all the Latin words. But there are some of the Latin words which you remember, like for example, audi altrum partem. That means no one should be left unheard or punished without hearing them. So this is something you remember. Yeah. Okay. You can type your questions. Please, keep typing your questions. I'm seeing your questions. You can, I think, unmute your mic also and speak if you have any other questions. In our next class, we will talk about the, aids, internal aids and external aids. This we will discuss in our next class. Yeah. Yes, I have been uploading the PPT, so you will get that particular PPT just after this session. I'll upload. Okay, then if there are no questions, then we can wind up the session today. Let me check last time the admin panel if there are any questions. Maitri, there is a question, when will CA inter September 25 batch start? That you have to ask to the administration department. How can I write long questions? Okay. See some sample questions in your study material that will give you an idea about that. There are some exceptions also of the Ejusdem generis Stambeshwari, and I think it is mentioned in your course material. And these are quite simpler, exceptions. If you have a look at it, it is basically saying if the preceding term is general, as well as that which follows this rule can be applied, where the particular words exhaust the whole genus, where the specific objects enumerated. Basically, wherever there is a clarity, you don't have to go ahead with this Ejusdem generis rules. And Ejusdem generis rule follows whenever there is a enumeration has got a sequence. Yeah, they have got some interrelationship. If they are completely different, then you cannot apply the Ejusdem generis rule, right? I think I have answered your query. Any other query? I think I have answered all the queries. I hope you like these sessions, though these are a bit more legalistic, and you may be wondering that whether we have to become lawyers after these sessions. In a way, you people will be doing all kinds of work, including the legal work. You may not go in the court and appear for parties, but you have to read the briefs and brief your employer wherever you will be working in future. You have to make sense of the orders which have been given by the court. Yeah, I think I have completed my the session. I'm just waiting if there are any questions. You can ask the questions. Otherwise, you can move on.